Good afternoon. I'm Megan Hankwich, Executive Director of the EPS Legal and Regulatory Services Division. On Monday, I sent a letter to Alberta Justice requesting a review of a decision by the Alberta Crown Prosecution Service. This is the first time that EPS has overtly sought to have the ADM review a file to potentially intervene and rescind a plea agreement. It was a step that was taken only after our officers repeatedly spoke to the Crown on this file, including when charges were first laid. This extraordinary step is also a culmination of close to a decade of consistent efforts by EPS to communicate serious ongoing justice system concerns. This includes many attempts to bring concerns to Assistant Deputy Ministers, Chief and Deputy Chief Crown Prosecutors, and other senior justice officials. Thank you. We have exhausted every consultation and collaborative step in our effort to achieve better public safety and a better criminal justice system. We have sought to own our own shortcomings where we need to do better and have maintained consistent positive lines of communication with senior and junior prosecutors. Despite our efforts over this lengthy period, we have grown only more frustrated, feeling further than ever from having our concerns addressed. In short, this is not the first straw. This case matters, and I want to talk briefly about the case now. As we stated, we worked with the Crown when we first laid first-degree murder charges in this case. And while we understand that the Crown has to present the case, there was no consultation with lead investigators or the EPS about the reduction of these charges. In mid-April, our investigators were made aware by happenstance of the prospective plea deal. This was despite close collaboration with the Crown through the investigative process. The shock we all felt in learning this news against what we knew of the case was significant. At no time has anyone from the Crown suggested that there are deficiencies in the file that would justify this path. The step we took on Monday, directly seeking to have the ADM and her superiors review the file to intervene in this process, was an extraordinary step. But it was a legitimate path for the ADM to intervene, and if ever there was a case that we believe should have made her do so, this was it. I know there are more questions than I'll be able to answer today, and this is simply because the case is still not yet concluded, and there are other files related to this one which are also outstanding. There are still publication bans in place, and we need to confirm what details remain covered by those bans. Full details of this file will need to come out in the fullness of time. This is what I can tell you today, based on the statement of facts accepted by the court in this plea deal today. I understand that the following facts were admitted about what happened to this child. The offender admitted to causing some of the prior injuries on the 8-year-old child. The court heard a significant list of recent and historical injuries that the child had suffered. The circumstances depicting a hole in the wall, a severely injured child laying in her blood, with blood coming from her mouth, were described without conclusion about what caused the injuries. The offender admitted she was aware of the injuries that the child had. She knew that medical treatment was required for those injuries. She failed to provide this medical treatment, and this caused the child's death. The offender did not seek treatment for the child and was more concerned about what to do with her body. Police reached out to the offender to do a welfare check, and she stated all the kids were fine and that the child had been picked up by her biological mother. Even this statement of fact only scratches the surface of the horrific circumstances of this offense, and nothing we heard today has changed how we see this file. We were advised by members of the child's family today that they only became aware of today's guilty plea date from yesterday's media reports. We understand from discussions with the family that they've experienced the same extreme difficulties in communications that EPS is facing. This 8-year-old child was failed so many times in her life. Her case remains one of the most horrifying cases of child abuse and ultimate death from abuse that our police service has ever seen. The trauma that our investigative and supporting teams felt in managing this file was extreme and is lingering for all of us. This child deserved a zealous and fearless prosecution, if only to give her a touch of justice in death, which eluded her completely in her too short life. We did not know this child, but our heart goes out to those who did. We cannot imagine how the pain of her loss will ever diminish for them. Our hearts are with them. Justice for this child, and for all of us, requires a willingness to stand up for it and fight for it in the full view of our community. And when our system fails, and to be clear, we believe it has failed today, that too should be done in full view of our community. People should see how their system works, the good, the bad, and the so very much that needs improvement. In the midst of this travesty, our intent is to keep fighting, to make sure the system stands up next time, and to be sure we do not have to see the next child failed. The only positive result that can come from this is to work to ensure that it never happens again. Thank you.
Hi, Jeremy with CTV News. Just wondering what, if any, sort of explanation you've received from the Crown or sort of you're aware of about why the change, from murder charges to this plea deal.
In discussing this with our officers who spoke with the Crown and also in the communication back from the ADM, we still don't have an explanation.
And it's a pretty drastic difference, right, between sort of minimum, maximum sentencing. Hey, can you just explain a little bit about the difference between manslaughter and murder?
Certainly. Well, there's a spectrum even within manslaughter. And you'll recall from seeing the letter and probably from the media reporting at the time of the event that there was another child abuse and death matter that was prosecuted out of Edmonton and covered in the news, which was regularly referred to as the Baby M case. And so the manslaughter sentencing can have a very significant range. In that case, while the plea was to manslaughter, the Crown had sought 23 to 25 years. So manslaughter alone doesn't necessarily limit a significant sentence, but there are obviously mandatory minimums without parole for both second and first degree murder.
I'm wondering where the 8 years came from, because the Crown in court today said that there is no joint submission, and I believe the family told us that they hadn't heard 8 years except in the media.
Certainly, and so the 8 years comes from a couple of places. In that first, that's what our officers were told by the Crown was the arrangement in this case. Then as well, that was included in the letter that we sent to the ADM as the basis for our concern. And I would have expected that if we were under a misapprehension of what the Crown's position was going to be in court, the ADM would have corrected that in her response, and that correction was not there. There was no suggestion that EPS's understanding of the 8-year joint submission was wrong.
So there was a back and forth before this was released, saying this is our understanding of the case, and then she had a chance to say,
yes,
you're incorrect.
Yes, in our letter, the 8-year joint submission was included, and there was no correction or suggestion that we were misunderstanding the facts. We found out that that wasn't the case, along with everyone else, as it happened in court.
I just wanted to say I think I completely empathize with anyone who feels infuriated by this decision, but is it not dangerous when police start intervening in prosecutorial decisions like this? They're separate for a reason.
This is an extraordinary case, and we have sought to have discussions with the Crown and collaborate with the Crown in a variety of cases, not limited to this case, over a number of years. The Crown, in their response, did seek out our contact with them in the future on this case and other cases, and does want us to raise our opinions to them according to that letter. So I don't believe that it's inappropriate for the police to raise their concerns. We need to be strong advocates for the justice system and work to improve the justice system. Writing a letter to the Crown and the ADM to attempt to resolve the issue is the proper lawful process.
What about asking the minister to intervene? Isn't that constitutional maybe violation or the separation of powers between the judiciary and the minister? Like, isn't that the justice system's role to make that decision on the sentencing and what happens?
So the case that I cited in the letter that was provided is a case that actually came up out of Alberta as well, going to the Supreme Court, called Regina and Nixon. And that is the case where the Supreme Court dealt with whether the minister or the ADM can actually intervene to undo a plea deal. And in that case, there was an actual intervention and the deal was undone. The Supreme Court said that it ought to be rare, and this case is that rare, exceptional circumstance in our opinion, but it is something that is lawful according to the Supreme Court.
I just want to direct the questions back to you.
It was mentioned yesterday that police may release more details of this case. In the agreed statement of facts, do you think this was a fair representation of what happened?
I don't think that I can comment on that at this time, as the sentencing has not concluded. And I don't want to prejudice the judge in determining that by releasing additional information. However, based on where we're at right now, it is our intention to provide additional information to the public once that process has concluded, and we've ensured that we are not breaching any publication bans or anything that remain ongoing.
You also mentioned that this was one of the hardest, most horrific cases EPS has dealt with. And the fact that this was also done to a child, but even if it wasn't, like, is this in general just a horrific crime?
Absolutely. I think the fact that it was done to a child increases the obligations of everyone in society to raise voices for those who don't have their own voices to raise. Children are particularly vulnerable in our society, and case law regularly recognizes the vulnerability of children and the reliance that they put on their caretakers. I think this case and the facts of it would be horrific regardless of who the person that it was done to was, but the fact that it was a child does escalate the horror of what happened in this case.
And the names are under a publication ban. We have heard from the family that they would like to see this lifted. Obviously, there's reasons for that, but I mean, do you think that is also an important element? Right now, we don't even have the person who pleaded guilty to this crime.
Certainly. Part of the publication ban and part of our review of what we can make public also recognizes that there were other children involved in this situation, and we certainly don't want to create any additional harm to those other children that were involved. So that's a very important part of the calculation for us in looking at what we're able to make public, is that we don't want to prejudice those children any more than has already occurred to them.
So as a lawyer, you understand very well the principle of prosecutorial discretion and independence. So where is the line now? Because when EPS has come out like this with this case, are you setting a precedent that you could do it for any case where EPS or officers who investigate don't like the outcome? Like, how do you kind of come back from coming out and doing this?
Certainly, and I think when you look at the Supreme Court's decision in Nixon, it talks very clearly about the importance that the minister or ADM's intervention, which is what we were seeking in this case. We did not go to court to seek to be interveners in court. We sought the ADM to review the file and determine what their position was. It is set out by the Supreme Court that it would be rare. We regularly discuss files with the Crown and raise concerns that we have on either a direct to Crown basis with their supervisors within that kind of private realm. That is something that happens regularly and is supported by the ADM in her correspondence back to us, that is what they want to see continue. Making it public and seeking to have the ADM review the file to potentially reconsider the deal is a rare and exceptional move, and the rarity of that is supported by the Supreme Court's decision in Nixon.
In that case, though, the ADM took action on their own. I don't believe there's any discussion in that case about police requesting that action. And so that's what makes this a bit different, is police coming out publicly and saying, we want this, and kind of everyone seeing that. And I know there's no precedent for this within EPS, but as far as you know, is there any precedent for police ever asking for something like this across Canada?
I'm not aware of one. I think the reason for our exceptional action in this case was the fact that we are at a point where we have exhausted every other option we have to try to raise our concerns with them. We've done that on numerous cases, sometimes with some success, many times with no success, in private, which is typically where this would happen. The extraordinary facts of this case, as well as the many, many years of advocacy directly to the Crown, is what led us to taking this very extraordinary step, which we recognize is not something that we would ever seek to do on any regular basis, and we very much hope to never have to do it again.
It was pointed out to me by a lawyer that the Crown really can't defend itself or explain its decision here. There's a situation where there are still two co-accused who are before the courts. The Crown has a duty to not do anything that could potentially prejudice their trial. You have the ability to call a media conference here, essentially that the Crown is fighting, or not fighting, but has their hands tied behind their back in terms of being able to explain why they made this decision, why they thought that this was appropriate. Can you comment on that at all? they obviously are not in a situation where they can say anything right now, and you're choosing to sort of go on the offensive against them.
Certainly, I think the Crown did have the opportunity to tell us what was going on, and they didn't take that opportunity either. So there would have been no issue in terms of a public spectacle of the Crown prejudicing anything in public for the Crown to have reached out to the officers rather than finding out by happenstance what the result was, to say, these are my concerns, these are my thoughts on the file, here's where I'm going, and had that discussion at that time. That does happen on files. However, our issue is that that's not happening on a regular basis with all people, and that we're not having the level of communication and essentially the level of respectful professional relationships that we really need to have for the justice system to properly function.
It pointed out to me, and unless I'm misunderstanding the organizational chart, the former chief of police of the EPS is Kim Goddard's boss. Was there any communication with him before, since this letter was sent?
Well, I think an important thing to remember about the prosecution service in general vis-a-vis the government generally is that there is also a very important independence for the prosecution, and that generally politicians don't go in it and make decisions other than the justice minister, who is ultimately the head of that organization. Nixon does, again, if you go to that case, talk about the importance of the separation of those powers and ultimately kind of whose discretion it is and where that falls.
Yeah, just to follow up on one of Johnny's questions there. My name is Lisa Johnson with the Canadian Press. You mentioned that it's routine for you to discuss with Crown prosecutors cases, but behind closed doors, not in public. We're in the middle of what many people think is a crisis in trust in institutions, in democratic institutions, the court being one of them. Today's decision is going to hit people, and could arguably, critics will say, this will undermine trust in the judicial system. So why did you decide to make this letter public with the media and not use back channels as normal? Like, what was it about this?
So again, a combination of the fact that all of our efforts in the direct kind of behind closed doors were not as a systemic issue, not working overall. We still are in the same place, if not a worse place, in terms of having our concerns with individual files, with overarching processes dealt with or responded to, getting feedback where if files are withdrawn and there's issues with the files. We would like to know what they are. Our members would like to get better, would like to improve. And we're not getting that in a realistic way. And then the combination of the years of frustration of not having that communication and those efforts function and improve the justice system, in combination with the egregious facts of this file, just really made it necessary to take that extraordinary step. We're out of other options to try to improve the justice system. It's all of our duty, the police, the Crown, the public, to try to fight for a better justice system. And that's what we're trying to do. We were out of other options.
I think that there's probably an accountability question, so if you'd like to address why the chief himself, who sent the letter, is not here addressing us today, that would be helpful. But at the same time, I need to ask, it's been pointed out to us by a defense lawyer that there are pieces of evidence that the Crown prosecutors could have that police are not aware of. They could have information from the defense that police are not aware of. Do you acknowledge that there are some things about this case that you may not know that has led them to make this decision, and where's the chief?
I think first, in relation to any additional information, I think the issue with that is if the Crown had received additional information, when we were asking, are there any issues with this file? Is there anything wrong? Do we need to address anything? We did not receive any additional information from them to tell us, actually, we have to take this deal because of this other additional information that we found out from defense or from case law or from any other point. As well, we aren't saying that when we provide additional information to the public that everyone has to agree with our interpretation of it. If once the matter is over, there's no additional jeopardy to the accused if they want to come out and dispute the evidence. So there's an opportunity as well for them, once everything is completed, to show us how we're wrong. We haven't received any information that would show that the evidence that we've collected is incorrect, or that there's some other piece of evidence elsewhere that would change what we believe on this file. Also, in relation to whether it's me speaking about it or the chief, I was the one speaking to the members about it. I was the one who wrote to the Crown. I used to be a Crown. I think I'm informed in a certain way about some of the legal issues here to be able to respond to some of the questions, particularly when we're looking at the issue of Nixon. There's some very kind of specific legal issues that, without making any offense to the chief, put me kind of in a good position to speak to. The chief doesn't come and speak on every issue that comes up.
So you're essentially making the Donald Rumsfeld argument that we don't know what we don't know.
In terms of
In terms of
our
the facts
knowledge?
of this case. I mean, you acknowledge that there are things that you don't know about this case.
I acknowledge that there certainly could be. I can't know if there is, but if there are, we would expect that someone would communicate that to us when we ask the Crown for that type of information.
I'll let Jenna go.
Yeah. Can we just come back to this 8 years? The impression from the letter is that there's perhaps a joint submission, an agreement for 8 years, and we didn't hear that in court today.
Certainly.
So do you believe that your original information is correct and, you know, maybe it was changed with the spotlight on it, or do you think that maybe that was something, you said that the police officers learned this kind of by happenstance.
Yes.
Is it possible that that information is incorrect?
I would have expected in my letter to the ADM that if I was incorrect in that misunderstanding, she would have come back to me and said, actually, you're mistaken. This is what the actual plan is. Because that would have been a very easy answer to say, you know, we are very upset about this, which is what we understand to be going to happen in court on Wednesday. If that wasn't correct, I would have assumed that she would tell me that I was wrong, and that was not in the letter that I received back. There was nothing to say, actually, you're misunderstanding the facts. So I don't know why that didn't happen today. I can't read their minds, and we found out in court, as everyone else did, that that wasn't going to happen today. But there was no indication to us, despite those opportunities, of them telling us that we were operating under an incorrect assumption.
So if the original information, or maybe even the officers, if they misheard something,
Right.
and actually there was going to be a contested, an agreed manslaughter plea, a contested sentencing, in which, like the Baby M case, you know, the Crown's looking for high double digits, and maybe the defense is starting lower. But does that change the police concerns, like with, does that change the police concern?
It would depend a lot on exactly what the rest of it would be, but obviously, if the facts were different, we might be in a completely different position. If it was more like the Baby M case, then I think we would have been much less outraged by the results that we were hearing. So obviously, if the sentence was different, we would have considered our options differently.
And so, but this first information of the 8 years seems like it's quite solid?
Well, again, that's what our officers were told. That was in our letter to the ADM, and there was nothing in her response that indicated that that was incorrect, despite that would be a reasonable thing I would expect to be corrected on if it was false, because that was essentially the premise of our letter. So if it was operating under a false premise, then I would expect that I would have been corrected on that.
Hopefully she read the whole thing closely.
Yeah.
Thanks very much. Thanks, Megan.